lines. Sometimes it's just understanding the clients, how they operate, where the risks come from. And we're not here to protect them from every risk under the sun. It's usually certain kinds of risks. And in a lot of businesses, you can prevent those risks from becoming a problem.
The way to put it, I think, is...
I got a question for Barry. Barry, how do you handle when you're first meeting a client? How do you handle that? What do you do? What's your normal procedure in the initial interview?
It varies, really, but learn as much as I can about who they are and what's on their agenda. I'd like to comment on something Howard said, and I think the way to put it is that asset protection is really more of a way of life rather than a reaction to a problem. But it really is a way of life, and this is something that I try to get across to clients in the initial discussion or interview as well. Who are you and how do you do things, and what can you just do as a matter of business practice or personal habits that expose you, and how can you change those? And in looking at this question of getting into the trenches here and what works, I don't know about your experience, but in my experience, I've seen situations where dummy real estate liens have worked, and I've seen cases where good structures have not worked so well. So going back to these variables, you never know what the result is going to be, and why a dummy lien that's filed of record might work and scare somebody off. Well, we all know that that's not something that you would counsel your clients on, right? Well, gee, let's just prepare a bunch of dummy liens, we'll file them, and nobody will ever touch you. That wouldn't be very good legal advice. But I've seen it work. It's not a plan I implemented, I've just seen it work. I don't know about you. Then I've seen not our own legal work, but I've seen other structures that should have had a better outcome at the end of the day when you compare where they ended up to where they should have ended up, and for whatever reason, they didn't work so well. Sometimes it's the constitution of the client himself or herself. I've had clients who have been, when challenged, great witnesses. I have one client, a doctor in Illinois, ask him a question, he'd start to twitch, wring his hands, and say, "What should I say?"
And that's on the stand to the jury.
That's exactly my point, is that nobody wanted this guy ever to get up in front of a court, of a jury, and be a witness. I had a client in a case, very well-to-do fella, his planning was proper, put together years before there was ever a problem. He just didn't have the constitution for a fight. He just did not want to go through it. So, in my opinion, he settled with too much money being paid by him. In his opinion, let's get it over with so I can move on, even though he had the structure in place. So these are things to take into account when it's not so black and white as, do these things work, do they not work? Many times I'll speak to bankruptcy attorneys. Somebody might comment, why are you going into the lion's den? Well, I don't really view it that way. I like to give a little perspective on what this is, the propriety of what this is, and many of them are educated then when it's all said and done about what we're doing and how we're doing it, and it's not just planning at the last minute. Now, what somebody can do at the last minute in Florida might be different than what they can do in California.
It is.
Yes, or Colorado.
A couple of points here, I see.
He does. All right, I'm happy to jump in. So, the question of, do asset protection trusts, or whatever you want to call them, the question of, do they work? You've had some experience, Howard. I'm sure, Dennis, you have. In fact, I've heard about some of your cases. I'd like to point out that I made a comment earlier. Of course, we tend to read about the cases that things haven't worked out so well, because that's what makes news, that's what legal principles are based on. Some important things come out of those cases, but we tend not to read about cases where things were settled. Most cases never go that far. We already know that, what is the statistic that we hear? 95% of all cases are settled on the courthouse steps or something. We also know that most statistics are made up on the spot. But whatever the real figure is, a high percentage settle way before. So our job is not necessarily to make, as I view it, to make or cause the other side to get scared, go away, disappear, to win every motion, to win every aspect of the case. To me, we measure whether or not a plan works by comparing what ultimately happens with where things would have ended up had there been no planning. So just because, say for example, a bankruptcy court finds that assets are property of the bankruptcy estate, what does that mean? What does that mean in particular if the trust is offshore and the assets are offshore and they can't be gotten to? So you have to look beyond just the words of a decision, and a lot of times we read the decision, we read what people write about the decision, and we still don't even know the real facts because there's a lot more behind the scenes that went on. But still, we can only go on the basis of what we see. But what does it mean when a court makes a finding or renders a decision that's contrary to the trust? It doesn't necessarily mean that the trust didn't work. You have to know how much money did that decision end up putting into the pockets of the adversary. We also know that in terms of measuring where things ended up versus where they would have ended up absent planning, we know that there's a number of variables, and I've identified some of these variables for you in my second outline on page 5. I say the following variables are generally of key importance in determining how a particular IEP, integrated estate plan, will fare if challenged. The client's net worth, the client's goals, the nature of assets transferred under the plan, the skill with which the plan was crafted, the skill with which it was attacked, the skill with which the plan is defended, the thoroughness and protectiveness of the applicable law, who the claimant is, and then, of course, the biases or bent, perhaps, of the presiding judge. Nature of assets transferred under the plan. That's an interesting one because some people would say, for example, don't bother to transfer U.S. real estate because it can't ultimately be moved by the trustees, in particular, the foreign trustee. Because if there's a threat, often one of the strategies is for the trustees to reposition assets out of harm's way.
Well, you certainly can't dig it up and move it out. I mean,
well, if it's a, double wide, maybe you can drive it away. But let's assume it's not a double wide.
They're one half my clients.
Assuming it's not, then of course recognize that over time things do change. We have had plenty of clients. I can't think really of too many clients that haven't put real estate in, because one easy way to look at it is what's going to happen if you leave the property out and if there's a threat or a challenge down the road. Not speaking of the Florida homestead. You know what's going to happen that way. Why not, through simply some paperwork, move the property in? Courts generally don't willy-nilly ignore the existence of validly created trusts, corporations, partnerships. At least you have a chance that way, but more importantly, recognize that over the course of time, things change. Property is sold, converted to cash. Equity is taken out in the way of a refinance. And, very importantly, at least you have created clouds and issues that the other side has to contend with that are much more complicated than if you did nothing and said, well, the real estate's here, it's the earth, it's the ground, it can't be moved, so we'll just leave it in your name. There, we know what the result will be. So all of these factors are important in determining what's going to ultimately happen and if the planning structure works. Timing, of course, is very important.